Greetings and salutations, my fellow Severns. This is the Saturday night Vocational Science of Freedom Civics and Savity class, and tonight we will be continuing our reading from a book named Thegreattaking. And if you'd like to download it, you can do so at the Gilded server, and also it will be in the show notes in a mega file on all of the platforms the Vocational Science of Freedom is on, which includes Rumble and YouTube and Odyssey. So with that, we left off at Chapter 4. Safe harbor for whom and from what? All animals are equal, but some animals are more equal than others. George Orwell, Animal Farm. In 2005, less than 2 years before onset of the global financial crisis, quote-unquote safe harbor provisions in the U.S. Bankruptcy Code were significantly changed. Quote-unquote safe harbor sounds like a good thing. But again, this was about making it absolutely certain that secured creditors can take clients' assets and that this cannot be challenged subsequently. This was about safe harbor for secured creditors against claims of customers to their own assets. Here are some explanatory excerpts from the online article, The Effect of the New Bankruptcy Code on Safe Harbor Transactions. On October 17, 2005, the provisions of the Bankruptcy Abuse Prevention and Customer Protection Act of 2005, the 2005 Act, became effective, amending various provisions of the U.S. Bankruptcy Code. Of particular significance are the provisions of the 2005 Act that addresses the bankruptcy treatment of various quote-unquote safe harbor transactions, such as forward contracts, commodity contracts, repurchase agreements, and securities contracts. Historically, under U.S. Bankruptcy Code, a bankruptcy trustee could avoid transfers, i.e., force disengorgement or repayment if the transfer was constructively fraudulent, i.e., less than reasonable equivalent value was received, and the debtor in bankruptcy was insolvent, became insolvent as a result of the transfer, was engaged in business for which the debtor had unreasonably small capital, intentionally incurred debt beyond his ability to pay. Yeah, that sounds about like what they're doing. Or made such transfer to or for the benefit of an insider. Well, that's all of them. Or the transfer was made within 90 days of a bankruptcy filing, 1 year if the transferee was an insider. Transfers that met any of the above criteria are referenced to as preferences, preference transfers, or preference liabilities. So now, with the new, quote-unquote, safe harbor provisions, the transfer of customer assets to creditors previously considered to be fraudulent can no longer be challenged. Yeah, that's a point to be made there. The transfer of customer assets to creditors previously considered to be fraudulent can no longer be challenged. So what does that basically mean in law? It means that, okay, fine. We're going to take whatever we want. We're going to transfer it to whatever bank we want. And they're going to be the secured creditor. And even if it was done under fraud, there's no way for you to possibly correct it. It can no longer be challenged. How convenient. And how a complete corruption of law that is. Let me start. Now with that new safe harbor provisions, the transfer of customer assets to creditors previously considered to be fraudulent can no longer be challenged. That was exactly the point. Further, it is now quite okay for the transfer of the public's assets to be made free of payment, as there is no requirement to show that reasonably equivalent value was received. Stephen J. Lubin is the Harvey Washington Wiley Chair in Corporate Government and Business Ethics at Stenton Hall University and an expert in the field of corporate finance and governance, corporate restructuring, financial distress, and debt. That sounds like a whole bunch of titles that just basically call him a thief. Below are some excerpts from his book, The Bankruptcy Code Without Safe Harbors. Following the 2005 amendments to the code, it is hard to envision a derivative that is not subject to special treatment. The safe harbors cover a wide range of contracts that might be considered derivatives, including securities contracts, commodities contracts, forward contracts, repurchase agreements, and most importantly, swap agreements. The latter has become a kind of catch-all definition that covers the whole of the derivatives market, present and future. Right. Swap agreements. I'm just going to swap this for that. We're going to write $25 billion on a cocktail napkin and exchange it with your cocktail napkin that you wrote $25 billion on. And then we're going to pay ourselves, 10% in a fee. For what? Nothing. But I digress. To continue. A protected contract is only protected if the holder is also a protected person, as defined in the Bankruptcy Code. Financial participants, essentially very large financial institutions, are always protected. The safe harbors, as currently enacted, were promoted by the derivatives industry as necessary measures, right, necessary to steal. The systemic risk argument for the safe harbors is basically on the belief that the inability to close out a derivatives position because of the automatic stay would cause a daisy chain of failure amongst financial institutions. Right, because you don't ever actually want to have actual accounting and have to actually stop a transaction because of fraud. No, we can't have that one. But to continue. The problem with this argument is that it fails to consider the risk created by the rush to close out positions and demand collateral from distressed firms. Not only does this contribute to the failure of an already weakened financial firm by fostering a run on the firm, but it also has consequent effects on the markets generally. The code will have to guard against attempts to grab massive amounts of collateral on the eve of a bankruptcy in a way that is unrelated to the underlying value of the trades being collateralized. Right. So why'd you go bankrupt in the first place? Is it possibly because you were constantly doing these kinds of trades? Right. To continue, the new safe harbor regime was cemented into case law with the court proceedings around the bankruptcy of Lehman Brothers. Oh, that's fascinating. I didn't know that. Huh. That makes perfect sense. Lehman collapses. They put it in and make a ruling. So, now it's precedent. Now it's case law. Not to say that it gives it any more validity. Fraud is fraud. But that's interesting that they did that. I did not know that. Let's use this as a perfect scenario to cement it into case law. To continue. In the lead up to the failure, JP Morgan had taken client assets as a secured creditor while being the custodian for these clients' assets. Right. Under longstanding bankruptcy law, this would clearly have been a constructively fraudulent preference transfer benefiting an insider. And so, JP Morgan was sued by clients whose assets were taken. Yeah, rightly so. I will cite the following memorandum filed in defense of JP Morgan by the law firm Wachtel, right, Lipton, Rosen, and Katz with the U.S. Bankruptcy Court of the Southern District of New York. The purpose of the safe harbors from their inception has been to promote stability in large and inherently unstable financial markets by protecting transactions in those markets from being disturbed during a bankruptcy. As explained in the legislative history of the original safe harbor, the quote, the financial stability of the clearinghouses with often millions of dollars at their disposal would be severely threatened by exposure to avoidance claims, as well actions to avoid margin payments made by clearinghouses could set off a quote-unquote chain reaction of insolvencies among all other market participants, threatening the entire industry. Well, okay. Threatening the entire industry. This entire quote-unquote industry, if you want to call it that, it's just a huge den of fraud is all it is. Nothing in the banking system and the financial system is based on actual reality any longer. There was a time long ago when it was, sure, when you actually owned your stock and corporations only did things for a certain short period of time and they had a charter, you invested, they did their job, the investors got paid back with a little bit of extra, and that was it. Okay, well, now with the derivatives markets, the swaps, the trading, the mortgage-backed securities, every single stupid thing that they've done for last 100 years and more, none of it is based upon reality. It's all fiction. And all they're doing is coming up with more and more ways to create more and more fiction, including, but not limited to, obviously, the Federal Reserve note itself. Because, as I said, Ibid, in Jerome Daly case, it was found that Federal Reserve notes have no lawful consideration. So, anyway, threatening the entire industry, this entire industry needs to end. Period. Full stop. It just needs to come to an end. And none of us, no one at all should have to be taxed, had their assets taken to bail out a fraudulent system. So, to continue. Now, here's the decision of the court. United States Bankruptcy Court, Southern District of New York. In re, Chapter 11, case number 08-13555. The court agrees with J.P. Morgan that the safe harbors apply here, and it is appropriate for these provisions to be enforced as written and applied literally in the interest of market stability. The transactions in question are precisely the sort of contractual arrangements that should be exempt from being upset by a bankruptcy court under the more lenient standards of constructive fraudulent transfer or preference liability. These are systemically significant transactions between sophisticated financial players at a time of financial distress in the markets. In other words, the precise setting for which the safe harbors were intended. The court must first consider whether J.P. Morgan is eligible for protection under Section 546E. That subsection, like the safe harbors generally, applies only to certain types of qualifying entities. J.P. Morgan, as one of the leading financial institutions in the world, quite obviously is a member of the protected class and qualifies as both a quote-unquote financial institution and a quote-unquote financial participant. Right. That's a black-robed priest of El just saying, yes, we're going to rule for our masters. That's all I just said. Because we don't want to rule against the banks now, do we? No, because the banks are the ones that run the United States Federal Corporation. And so only, quote, a member of the protected class, close quote, is empowered to take customer assets in this way. Smaller secured creditors are not similarly privileged. In the aftermath of the 2007-2008 global financial crisis, no executive was convicted of a crime for the use and subsequent loss of client assets. Quite the contrary. The bankruptcy of Lehman Brothers was used to establish case law precedent that the quote-unquote protected class of secured creditors has an absolute priority claim to client assets, and that, potentially and practically, only they will end up with the assets. And to make a point here, I highly suggest that everybody go watch a movie called The Big Short, and I also highly suggest that everyone go watch the documentary that I just put up, Inside Job. So if you haven't seen Inside Job, watch it. It doesn't matter where you watch it. I put it on all three platforms. I put it on YouTube and Odyssey and Rumble. And seeing as how YouTube has not given me a strike for it yet, I'm pretty sure it's past its copyright aspect, which is, I think, 10 years. So everybody needs to go watch that to get the rest of the information as to what is actually happening. And if you want a real full information as to the totality of the history of all of this, go to the Vocational Science of Freedom on Odyssey, click on playlists here, and then go down to the banking timeline right here, how bankers stole the world, and watch the entire banking timeline. This will give you a whole breakdown as to how all of this system has been evolving, morphing, changing over the last several hundred years, not just recent American history. So make sure to do extra homework and know your history. Next chapter. Chapter 7, Central Clearing Parties. Humpty Dumpty was pushed. Mr. Potato Head, Toy Story. Central clearing parties, CCPs, take on counterparty risk between parties to a transaction and provide clearing and settlement for trades in foreign exchange, securities, options, and most importantly, derivative contracts. If a participant fails, the CCP assumes the obligations of the failed clearing participant. The CCP combines the exposures to all clearing members on its balance sheet. If there is a risk that CCPs might fail, Euroclear is an international central securities depository, ICSD, and we talked about ICSDs a few classes back from this reading, which was designated to channel customer collateral to CCPs, which again is central clearing parties. In 2020, Euroclear published an article discussing the possibility of failures of CCPs. Right, because that's coming. Regulating the risk of CCPs, in which we find the following remarkable statements of panelists at Euroclear's collateral conference. Regulators around the world have demanded more capital, more collateral, and more clearing. And to a large degree, they now have what they wanted. And yet, despite the huge efforts undertaken by market participants, there are still two major concerns. The first is that financial regulations from different jurisdictions are not fully aligned with one another. Right, which we talked about in a few previous chapters before. Just to make a point here, this refers to different jurisdictions. Right. You can't have something like, say the common law come in and say, whoa, hold on, this is all fraud. No. And we're going to put it to a common law court of record. And a court of record is a court that proceeds according to the course of the common law, and allow a jury under a general verdict, which is where the jury decides both the fact and the law, to come along and say enough is enough. Can't have that happen. So anyway, that's what this is in reference to. Can't have these other, and even state jurisdictions, even different nations with different laws. No. Can't have that either. This whole entire thing about altering the law globally so that they can take everything they want to. This is the first step in the New World Order. So, to continue. And secondly, that the risks of the financial system have been concentrated into central clearing counterparties, CCPs. These two issues come together in the upcoming regulatory push to devise resolution and recovery regime for CCPs around the world. The EU's push to create a recovery and resolution regime for CCPs has also created tensions between the clearinghouses themselves and their clearing bank and asset manager members as to who should pay what in the event of a collapse of these critical market infrastructures. But for the EU institutions, the red line, Sync, is that if a CCP fails, then the taxpayer will not be expected to pay. Let's see how that turns out when it happens. The last paragraph is a subterfuge assuring that in the resolution, the secured creditors will immediately take the underlying assets. That is the plan. There's no other plan other than that. That plan has been laid down for a very long time. And to make a point, there are even other plans in place, not specifically dealing with securities, but even dealing with your money that is in the bank that you think's yours. There was a bail-in provision, and I believe it was put in the Dodd-Frank Act, I think. Don't quote me on that exactly, but I think that's where it got thrown in. And there's a provision in there that allows the banks to take your money. We're not talking about derivatives. We're not talking about stocks and bonds. We're talking about the money you have in your bank. So all of it is already in place without question, able to be taken instantly. But to continue, the report goes on. In whatever way the final text of the regulation is balanced, it does not detract from the fact that risk is now heavily focused within these institutions. One of the Euroclear panelists suggested that there is resistance to the ever-increasing march towards central clearing as a risk management function, and functions do occasionally fail. Indeed, just because CCPs have not failed in the past, there is nothing to say that there will not be a CCP crisis in the future. Well, of course there will be. There's no question that that's going to happen. So panelists were concerned that with the small capital-based CCPs currently have, any recovery and resolution of a failing CCP will involve direct clearing members standing up to support them through a number of difficult actions for the firms involved. One of the key requirements of the draft paper will be a requirement for the CCPs to undertake scenario planning. And for a CCP to fail, it will likely have been triggered by the simultaneous default of two major members. Quote, if a large CCP is in trouble because of its members' default, then we will be having a banking crisis, says Senior Director of European Policy at ISDA. In 2022, the Financial Stability Board, FSB, and the Committee on Payments and Markets Infrastructure at the BIS published the report Central Counterparty Financial Resources for Recovery and Resolution, in which we find the following statements. In November 2020, the chairs of the ISB, the Committee on Payments and Markets Infrastructure, the International Organization of Securities Commissions, and of the FSB Resolution Steering Group publicly committed to collaborate on and conduct further work on CCP financial resources in recovery and resolution. Such work would consider the need for, and develop as appropriate, international policy on the use, composition, and amount of financial resources in recovery and resolution to further strengthen the resilience and resolvability of CCPs in default and non-default loss scenarios. All right. So what did they have to do to get together? Because the whole entire world financial system is collapsing. And it is collapsing because of all this ridiculous amount of derivatives and all these stupid games that they keep playing. Again, make a point to watch The Big Short. Very good movie. Explains all this with a little bit of satire and, that Hollywood flair for you. So, to continue. Under the subheading, quote, system-wide and contagion effects, like it's a disease spreading around, and interconnectedness, close quote, the same report states, because the scenarios were specific to each CCP, the results cannot be aggregated to simulate total losses at the level of the financial system for any particular scenario. Right, because they don't know what's coming. Therefore, system-wide effects were not considered. Oh my God, you got to be kidding me. They didn't even consider system-wide oh man. Okay, anyway. To continue. The analysis did not take into account the underlying economic circumstances that would cause the simultaneous default of 4 clearing members at each of the 7 CCPs, the likelihood of such circumstances or the potential impact of the same clearing members defaulting in multiple CCPs. Neither did the analysis endeavor to model second and later order effects of the scenarios that might result in wider market stress, including potential increase in margin requirements, liquidity pressure, and collateral scarcity. Right, all the things that are going to happen.
So they just admitted they didn't even do their full due diligence.
Precisely. Well, and they can't because it's impossible. Because there's going to be so many things that are going to happen when this crash happens. I mean, there's a million things that can trigger it. So could they possibly prepare for a million scenarios? No. But yeah, you're right. They literally just admitted it's impossible. I don't know about not due diligence, but it's literally impossible for them to come up with every single possible scenario and put it into some sort of plan. Like, and then also try to write it into law. Fuck that. That's never going to happen. So anyway, to continue. Finally, the analysis assumed that all non-defaulting participants continued to perform as they had committed to. Yeah, right. Thus, this analysis provided by the Financial Stability Board of the BIS absolutely avoided contemplation of exactly what happens in a global financial crisis, right? Which is precisely what I just said. The Depository Trust and Clearing Corporation, here we go. This is the major player, operates 2 CCPs, both of which have been designated in the U.S. as systemically important financial market utilities. Okay, and to make a point, we need to, whatever this is, whatever these 2 CCPs are, we need to find them and absolutely make sure that we put them into the VSOF committee for the DTCC research. Just on a side note, if anyone wants to take a look at that and do a little homework, please make sure to throw it into Committee 7 under the DTCC information, if we can track that down. Thank you very much. Okay, to continue.
You remember that scene from the movie War Games, where the computer's like trying all these nuclear war scenarios out, and all of them just result in annihilation?
Yeah, that's a good scenario.
That's basically the market.
Yeah, that's a very good analogy as to what is basically going to happen here. Right. The system itself will keep trying to come up with, well, and it is. I mean, this is the book that we're reading. This is the system itself trying to come up with ways to solve a insolvable problem, which is exactly what the little AI computer system did in that movie. It's like it just kept running and running and running and running and running and running and running scenarios, and it finally said, well, enough's enough. There is no winning solution. And
the only winning move is not to play.
Yeah, exactly. Yeah, and that's exactly what we're facing here on a real level with your financial, well, with your assets, your energy. Let's just put it that way. The only place anybody should be putting their energy right now is an actual physical gold and silver, and have it in a safe at home, protected with firearms. That's your best bet. All right, to continue. The following excerpts are from an article published by DTCC. Okay, good. So now we're getting it directly from the horse's mouth, if you will. With 3 of DTCC's clearing agency subsidiaries declared as systematically important financial market utilities, Ponsmatter, the DTCC head of Clearing Agency Services and Global Operations, said, there has been significant effort and discussions this year to update the clearing corporations and their depositories recovery and wind down plans. Wind down sounds like they know the whole thing's going to collapse. That's a little creepy. Anyway, he asked panelist Stephen Pakia, DTC Managing Director, Recovery and Resolution Office, about the updated wind down rules as well as some of the changes to the clearing agency loss allocation rules. Quote, the covered clearing agency standards required plans for orderly recovery in a wind down, Pakia said, and I might be butchering that name. Quote, we would seek to wind down the failed entry and concurrently shift our services to a third party that has neither stood up with the DTCC enterprise or would be some other third party acquirer. What will happen is essentially a transfer of services. There will be some assignment of assets. There will be service agreements put into place between the failed clearing agencies as well as between the DTCC holding company and this new entity. Hopefully this is something we will never have to do, but right there, that's something they know they will have to do. But we do need to be prepared, he said. As many of you know, what will drive this potentially happening may not be something we've seen historically, but the value comes in the planning, right? Because they know what's going to happen. Okay, so what we're going to have to look for, and DTCC, by the way, has already moved, apparently. So what we have to make sure is to keep track of DTCC, everything they're doing, all of these side clearing companies, and make sure that we have a record of all of them. Because when we send our bankers boxes to DTCC as a grand jury for everybody that's done their VSOF status doc set, and we're going to start doing these in 25 of us doing it together, and sending a claim of our estates, of everything that they hold, we're going to have all of the information needed to serve any one of these little critters that they've created on the side. All of the DTCCs, CCPs, and any other agencies or agents that the DTCC might try to move or hide things in, basically. We're going to have to hit them all at once. So, okay, to continue. So, something which has not been seen before will drive the imperative to start up a new CCP, and they are planning for it to happen. DTCC has provided a video clip, titled Perspectives on CCP Risk Management, in which Murray Ponsmatter makes the following statement. We believe the level of capitalization of a CCP is a key component of its overall resiliency. CCPs must be sufficiently capitalized in order to withstand losses from both member default and non-member default loss events. In response to this, we have implemented a comprehensive capital framework to effectively measure and mitigate risk and to support the resiliency of DTCC and our subsidiaries. Right, which every single subsidiary we need to have all of the information for, particularly the registered agent information, which is where we'll serve the documents on. What then is the capitalization of DTCC? This is an excerpt from DTCC's consolidated financial statements as of March 2023. The Depository Trust and Clearing Corporation is the parent company of various operating subsidiaries, including the Depository Trust Company, National Securities Clearing Corporation, Fixed Income Clearing Corporation, DTCC, ITP, LLC. I'm not even going to try and read all this. This is because it's just a bunch of letters that don't mean anything. Okay. Collectively, quote unquote, company or companies. This is all of DTCC consolidated. Okay, so what I'm going to do right now, just going to copy and paste this right into the committee. So I don't even have to worry about it later. I'm just going to make sure that it's in there so we have it for later. This is all of DTCC's consolidated, i.e. the whole enchilada, which is exactly what I was just asking for. So they gave it to me anyway. As of March 31st, 2023, the consolidated total shareholders' equity was a tad over $3.5 billion. That's with a B. Now realize that this is the entire capitalization underpinning the Central Securities Depository and CCPs for the entire U.S. securities market and derivatives complex. Well, that seems rather small, doesn't it? $3.5 billion? That doesn't seem like anything. That should be T, not a B, in my personal opinion. But anyway, contrast this with which just goes to show how much the derivatives market is out of control. Contrast this with the cited statement. We believe the level of capitalization of a CCP is a key component of its overall resiliency. CCPs must be sufficiently capitalized in order to withstand losses from both member default and non-member default loss events. This is one of the many open deceptions, which are unpleasantly and inconvenient to see, and so readily dismissed. Now, recall these excerpts from the exchange between the Legal Certainty Group and lawyers for the Federal Reserve. Question, EU. Is the investor protected against insolvency of an intermediary, and if so, how? Answer, New York Fed. An investor is always vulnerable to a securities intermediary that does not itself have interests in a financial asset sufficient to cover all of the securities entitlements that it has created exactly in that financial asset. So they just keep creating shit over and over and over. If the secured creditor has quote unquote control over the financial assets, it will have priority over entitlement holders. If the securities intermediary is a clearing corporation, CCP, the claims of its creditors have priority over the claims of entitlement holders. All right, what that's saying in a sense after what we just took a look at here, the DTCC is now poised to steal everything. So we need to get this done this fucking year, people. So if you have not gotten your Vocational Science of Freedom status doc set done, this might very well be the last year of the cutoff point if you want to join us in attacking the DTCC and getting what they have. Because if you don't have your doc set done, you don't have standing to have claim. Okay? Because what they're doing is they're administering everybody's estates as infants. Well, and that you're dead to the law, that no one ever came back to claim you back from the foundling hospital. So you have to get your doc set done first to have standing, and then we'll do it as a grand jury. And then if we need to, we will create our own trust company and force the DTCC to transfer it to our trust company. But that's a final move that may or may not need to happen, but I'm looking into that. But anyway, so to continue. So there we have it. In the collapse of the clearing subsidiaries of DTCC, it is the secured creditors who will take the assets of the entitlement holders. This is where it is going. It is designed to happen suddenly and on a vast scale. Right. Do not underestimate what this man just said. There are some further relevant statements in the article DTCC details risk management approach. Much of the debate recently has focused on whether CCPs should make larger contributions of their own capital to the loss allocation waterfall as a way to make sure that their risk management is prudent and that they had their own skin in the game, if you will. An argument could be made that CCPs that are publicly traded may potentially not be aligned with the interest of owners and shareholders who also used its services. Quote, we felt it was very important to point out that this argument isn't applicable to DTCC's CCPs because, in essence, the source of our capital is our users, Ponsmander said. Quote, we don't feel that putting an outsized portion of that capital at risk as part of our loss allocation waterfall would align with our interests any better than they're already aligned with our owners and users. Right, because you don't want to put yourself out there. You want to make sure that you can steal it all. Anyway, we look at that as potential source of instability in a stressed market. You better believe you do. He added, quote, while we're in favor of having some of our capital in the loss waterfall, we think that having a very transparent methodology and a static percentage of our operating capital in the waterfall is what's most appropriate for us. I'm going to start rubbing my hands together and talking differently. As for resolution procedures, DTCC is opposed to pre-funding the default loss waterfall. Although it doesn't support pre-funding, the operating capital needed to get a new CCP up and running in the event of a default. Quote, so as we go through our recovery and resolution planning, we want to have the operating capital pre-funded to potentially start up a new CCP in the event of the resolution of one of our CCPs, Ponsmeyer said. We definitely see the logic in having an operating capital to start up a new CCP pre-funded. Close quote. What's that? That's the little suitcase underneath the bed that they grab when everybody finds out what they're actually doing. Every Luciferian has them. That's what that is. Anyway, to continue. There you have it. The CCPs are designed to fail. They're deliberately undercapitalized. The startup of a new CCP is planned and pre-funded. This construct assures that the secured creditors will take all collateral upon which they will have perfected legal control. Right, because who actually controls the entire system? Attorneys. Who's your mortal enemy? Attorneys. What allows all this bullshit to happen? Attorneys. They say the bankers and, they're the problem. Well, hold the fuck on. Who's changing the law? Attorneys. Just remember that. To continue. The rule of law must prevail. We could have chaos otherwise. No one is above the law after all. Right. The attorney would have you believe that no one is above the law merchant. See, that's what this is. This is the law merchant. This is Roman civil law. Also, maritime admiralty law. That's morphed into what? The Uniform Commercial Code.
It's all just theft by conversion.
Yes, exactly. It is theft by conversion, precisely. And it's also all in the aspect of what the law merchant is. The law merchant, and I've done classes on this, just look for them. But if you ever want to really have your hair blown back, go look up the fair court of St. Ides was. Fair court meaning not fair as in equitable, but fair as in, like a county fair. Go look up the fair court of St. Ides and realize that that's where the law merchant first put its little toes off from the sea, off from the ships and onto the land. That's where they first started having actual law merchant courts. And if you were subject to their law, it was whatever they said it was. And surprise, surprise, that's exactly what black robe priests of El are doing on the bench right now. Why? Because we're not running our society on common law. We are allowing the attorney to take over everything and to pull us all into an inferior form of law. And that's kind of what he's jesting about here. Right? The rule of law must prevail. We would have chaos otherwise. No one is above the law after all. Right. This is all the things the attorney says. Right. But am I subject to your inferior law? No. Are you subject to my superior law when you're operating in my fucking land? Yes, you are, you filthy little son of a bitch. And common law theft still applies, motherfucker. But they won't have any of that, right? They don't want that. No. Anyway, I digress. To continue. As a reminder of the structure, here's an excerpt from the Wikipedia article on DTCC. Not that Wikipedia is any great bastion of reality, but anyway. Most large U.S. broker-dealers and banks are full DTC participants. Exactly. Meaning that they deposit and hold securities at DTC. DTC appears in an issuer's stock records as the sole registered owner of securities deposited at DTC. Sole registered owner. Registered. So you gave it to them, and then they decided to register it. Great. With what? Themselves. And what is the DTC and the DTCC? It's a trust company. How many people does it take to create a trust company? 25. Don't you find that number to be slightly odd? Because it happens to be the same number that it requires to create an actual real grand jury. That's right. You can go look it up in the District of Columbia code. In the DC code. It's in there. It takes 25. I wonder why that number is the same. Anyway, to continue. DTC holds the deposited securities in fungible bulk, meaning that they are no specifically identifiable shares directly owned by DTC participants. Exactly. Just bundle everything together, throw everything together, muddle it all together. No one knows who owns what, right? Why's that? Can't have an actual accounting, because then if the heirs come forward, that'd be a real problem, wouldn't it? Rather, each participant owns a pro rata interest in the aggregate number of shares of a particular issuer held at DTC. Correspondingly, each customer of a DTC participant, such as an individual investor, owns a pro rata interest in the shares in which the DTC participant has an interest. Again, let's just keep muddling everything, right? That's what the attorney fears most. That's what the Bar Association fears most. That's what the Black Robe Priests of El fear most, is what we are fucking doing here at the Vocational Science of Freedom, which is claiming back our estates under the common law. The only way you can do it is under common law. And it's laid out in the Magna Carta, Article 3, 4, and 5. Go read it. This is what they fear the most, is what we're doing. And this is why they're doing this shit. You notice how this book was written last year, and DTC and all the rest of these guys are doing all these things because they know we're coming, meaning us, meaning the people here. Not any of these other morons out here trying to actually pretend that they know what they're doing. Like Anna Von Dipshit. There are a few people out here that are actually helping people get their status changed, meaning that they're no longer being United States citizens. But no one out here is helping anybody claim their estates back, except us. That's it. Full stop. And what did the DTCC have to do in response? Exactly what they're doing, what we're reading here. We caused this. Make no mistake about it. Because they know what's coming. They know we're coming. So anyway, last sentence. With the explanation provided by the Federal Reserve Bank of New York. See Chapter 3. You know what this means? Bank holiday. And this is where we'll come back to. So, 10 minutes left. Let me go back and chat real quick and let me read off, aside from the memes. Knucklehead said, isn't that what the Great Reset is all about? It's a pre-planned, organized takedown of the system so that the elite retain their wealth and assets and everyone else is shit out of luck. Yes, exactly. That's precisely what it's about. They've done this multiple times. How far do you want me to go back? let's say, fuck it. Let me go all the way back. The burning of Rome. That was done by the agreement of the Senate and Nero. What happened after that? Oh, they passed a few laws that said, well, if you don't come forward and claim your estate and claim what might be yours, guess who gets to keep it? Caesar. Let me fast forward a little bit. What other time did that happen? Oh, I know. Just a few years prior to 1666. Happened to be a big fire in London. Everything got burned to the ground, with the exception of the city of London. Surprise, surprise. Because that's not part of England, but I won't get into that. 70,000 people wiped out. What'd they do after that? And by the way, they started the fire on purpose. And what'd they do after that? The Thegreattaking Act. Go read the Thegreattaking Act of 1666. It says, if you do not prove to have been found to be living in an action, what? You have no claim. You have no standing. So what do we do at the Vocational Science of Freedom? Make goddamn sure you have standing under the common law. We prove that you've been found to be living in an action. And we also prove that you've come of full age, which takes care of both the Thegreattaking Act and the requirements under the common law in the Magna Carta. That actually claims one estates, right? So, CLF3 says in chat, why do you think the hedge funds are buying all the land? Precisely. China is so oversupplied with real estate development condominiums that they have a surplus of something like 1.2 billion empty homes, and they keep buying more and try to protect wealth from the crash they know is coming. Right, because they're trying to put it into real estate. Well, that's okay. That's their way of doing it. The real way any one of us, anybody that's listening to this should do it, is gold and silver. Now, if you buy land here in America, meaning farmland that hasn't been destroyed by some Monsanto poison, meaning you want to buy some land that has a little bit of farmland on it and mostly forest, that's a good investment. As long as you make sure that it's allodial land, or make sure that you do the declaration of allodial lands that CLF3 mentioned, which is one of the things that the Vocational Science of Freedom can provide, which is making sure on the public record that your land is declared as allodial from the original land patent signed by the President of the United States of America. So it wasn't the same year, Knucklehead. So Knucklehead asked, was it in the same year Fire of London and Thegreattaking Act? No, it was not. It was I think a year or two before that. I believe it was 1664, I think the fire happened. Somebody could look it up very quickly online. When was the Great Fire of London? And I think it was 64. But I could be wrong. I know that they did it right afterwards. So, all right. So last 10 minutes. Anybody want to comment, question, add to, detract from? Oh, it was the same year. Oh, okay. I thought it was a few years before that. Okay. So good correction. Thank you very much for that. So the fire was in 1666. That's a good point. There were also the Chicago and San Francisco fires, other large stock exchanges. Yes, that's true. That is true. And if we're going to talk about setting things on fire, you can always go back to the War of 1812, where the Rothschilds systematically went through and burned practically every single courthouse in America to destroy the proof of the passing of the original 13th Amendment, which was a clause that was in the original Articles of Confederation.
We have a copy of it. Post it.
Say again, I didn't hear you.
So we have a copy of it. Post it. Remember, it's in that Territory of Iowa book.
Yeah, it is, and it.
Here you go.
Yeah, anybody can find it pretty quickly. The original 13th Amendment is not that difficult to find. They've tried to bury it, but it's available in all kinds of places. And but yeah, okay, yeah, it was in the territorial laws of Iowa was where it was originally, or where the one that you're referring to. Yeah,
the government's own website.
Yeah. Okay. Oh, okay. Well, there you go. Right. Yep. So yeah, the 13th Amendment is there. If anybody wants to go look at it, don't take our word for it. Go look it up. And it clearly shows that the 13th Amendment was passed, ratified, and is in full force and effect in the Republic. But of course, they're running everything out of the United States Federal Corporation. So of which we should all leave post haste. And if you haven't left post haste, all the more reason to get your Vocational Science of Freedom status docs done. So, anybody else have any questions or comments or additions to be had for this evening? No? Okay. Well, with that, we will come back to Chapter 8 here, Bank Holiday, on the next Vocational Science of Freedom Saturday Night Civics and Sovereignty class. So, and always make sure to sign up for the Civics and Sovereignty classes. Make sure you go to the VSOF event calendar and please click on the date and please go and then click on it. And then all you have to do is right here, click join, and then you'll be signed up and that's your RSVP. So it lets me know how many people on the server will be showing up for the night. And that gives me an idea also if I'll be doing class or not, because sometimes a lot of people show up, sometimes don't, but I do these classes for all of you here on the Vocational Science of Freedom Gilded server, and those that are lucky to listen to them on my platforms, that's fine after the fact, but I do these classes for you guys that are here. So with that, I hope all of you have a wonderful rest of your weekend. Please make sure to pass these classes on. I think this is a very important book that we're going over. I think it's very important that everybody realize what's coming, and I think it's very important for everybody to protect their assets. So, until next time, stay safe and stay sovereign.